then that is the end of the dispute. Because the both parties sign the conciliation agreement voluntarily in the presence of independent conciliator, and it is enforceable as per arbitration award. So there itself, and the time taken is very short, which we discuss in next slide. Here this flow chart, that mediation by authority engineer, then DRB, then conciliation, then arbitration, then High Court or Supreme Court. Beauty of conciliation is that from arbitration stage also we can come to conciliation, from court case also we can come to conciliation, so there is no stage for that. In NHAI, arbitration is institutional and it is being done under Sarod rules. Sarod is nothing but Society for Affordable Redressal of Disputes. So it is institutional arbitration. As now in the very beginning, there is provisions being brought out in agreement that arbitration will only be conducted under Sarod rules. In old agreements, there might be ad hoc arbitration, there might be ICA arbitration, but now in the new agreement, there is essentiality of going through Sarod arbitration. Apart from that, as I was talking of conciliation, conciliation has come into play in NHAI from June 2017, and it is outcome of Cabinet Committee on Economic Affairs decision. Right now, there are 3 committees of independent experts, each committee having 3 members, and their unresolved DRB or even after arbitration cases are being referred to CCI. This is the success rate of CCIE. Total cases referred till date from 2017 is 305. Out of that, 204 cases are successful. 41 cases have failed. 42 cases are ongoing. Settled cases, claim amount was 51,000 crore and settled amount is 10,000 crore. So that is the rate of the success, and in a very minimal time, maximum 1 year, generally 6 to 7 months. Here is another analysis of that out of 204 cases settled, those brought out from after arbitration award were 66, and claim amount was 21,809 crore, and they were settled for 7,869 crore even after arbitral award. Court cases, that is when the decree of the court was out, there were 22 cases and they were again brought to conciliation. Amount was 4,968, say roughly 5,000, and settled amount is 1,400 crore. And fresh cases, that is right from the site or from DRB. So those were 116 cases. Claimed amount were 24,000 crore, 24,819 crore, and settled amount is 8,184 crore. So overall figure, if you could see, that percentage settlement amount stands at 34% average. Considering this, and after due analysis and success of this conciliation, Government of India has brought out now Vivad Se Vishwas scheme, I think everybody might be aware of. And NHAI has received roughly 80 cases amounting to 8,000 crore for settlement under Vivad Se Vishwas. This is DRB, as I was telling that it is a prerequisite that first you have to refer the cases to DRB during execution of the project. So total DRB member impaneled as on date is 167. It is slightly more now, it is not updated. DRB constituted, that is project, on the project, 218 DRB is functioning, 28 are under constitution. And mind it, each DRB is having 3 members. This is right now the current arbitration matters which is ongoing in NHAI. Presently, 117 arbitration matters amounting to more than 1 lakh crore is ongoing, where NHAI is making counter claim of 47,000 crore. Matters under conciliation, out of that referred is 13, reserved for award is 22. So 152 cases are live under arbitration, and it is 1.25 lakh crore. State-wise, if I can make, Tamil Nadu tops the list, then Rajasthan, UP, Maharashtra, Haryana, Gujarat, Karnataka, MP, West Bengal. We have made some 17 high-stake projects analysis, and amount for 17 these projects were roughly 4,000 crore. And as per analysis, nearly 32% award amount was for delay in handing over of ROW, 5% for declaring in appointed date, bonus for delay accounted for 8%, interest on performance bank guarantee 4%, change of a scope 11%, and rest are others. Here again, a status of pending court cases. As we have seen, 152 ongoing arbitration cases. Apart from that, whatever arbitration award we have got, many of them are in court. So number of cases in High Court is 192, 27,858 crore is the award amount. These are the breakup. And in Supreme Court, there are 27 cases for 1,000 crore. The common grounds for arbitration as per analysis is emerging. Non-fulfillment of condition precedent by the authority, that everybody knows, that land acquisition or forest clearance or your railway GAD. So these all are the reasons. This accounts as prolongation cost, so idling cost, overstay, overhead, overrun. On this account, there is claim of loss of revenue, loss of capital, then of course termination payment due to untimely termination of the project, change in law, force majeure, competing roads, damages by authority, whatever damages we are imposing due to certain defaults, they are also being challenged. Utility shifting, tree cutting, excess payment of authority engineers, delay in payment by authority. So these are the probable reasons for and common grounds for generally all the claims. So thank you for your patient hearing.
Thank you, Pawan Kumar ji, for giving the information about what is the seriousness of this issue. I think more than 1,78,000 crores are in dispute by either way. But it's really good to understand and know that conciliation is probably proving effective, because even claim amount settlement is hardly 32% or something, so it's a very nice. And that means either party is agreeing that they have made a false claims, yes, or inflated the claims. Yes. So it's a really good, I mean, and hopefully in shorter time we'll get that zero number of cases, I mean, hopefully.
Due to Vivad to Viswas, a scheme brought out by Government of India, where the awards made by arbitration or court can be admitted. So if arbitration award is made up to 31st January 2023, that is the first prerequisite, and court award up to 30 April 2023. So they are admissible under the scheme. So if it is alone the arbitration award alone, then 65% of that amount. And from the date of 80 award till date of settlement, 9% interest. If it is court award, then 85% of that amount and 9% interest from the date of 80 award till the date of settlement. So this is simplistic form of this. So nearly 80 claims have been received. So as I was reading that 192 plus Supreme Court some 10, so 210 cases are there in courts. So they will be substantially reduced. Thank you.
So now I'll request our esteemed panelists to give their views on the list. First, I'll start with Sri Nirmalji, Secretary General IRC. 7 minutes each, I think.
Thank you, Chairman. So first of all, the importance of this particular issue, because when we were debating that what should be the topic of panel discussion, then lot of issues, lot of subjects were discussed, and we found out of all the subjects that at the moment, this arbitration is a very important topic. So dispute resolution, we should discuss in this panel discussion, considering the importance. Now, Government of India also has taken very seriously about the dispute resolution issues. And about 3 months back, highest level, Ministry of Finance, they constituted a committee under Law Secretary to review the arbitration law. So first of all, let me give just a brief of the history that first direct law on arbitration was enacted in 1899, that is more than 100 years back, 1899, and which was then 1940, it was Indian Arbitration Act, 1940 was enacted, and then 1996, where there overall it was reviewed, and this act was 1940 was repealed, and Arbitration and Conciliation Act 1996 based on the UNCITRAL model law, and it was passed by the parliament, and this act was substantially amended in 2015, and there were some amendments also in 2019 and 21. So now this particular committee, which was set up about 3 months back under Law Secretary and with experts from different stakeholders, different sectors, they were asked to submit a report within 2 months, and I think they are given extension for another 2 months. So by the end of this month, they are expected to give the report, and it is for substantial revision of the entire act. So Ministry nominated me also because IRC is doing arbitration, so I am also a member of that committee, and NHI for road sector, we are the members, and other sectors also there are members. So in that meeting, when I was to give comments, because Ministry wanted that we should give comment what we want amendment in this particular act. So I discussed this issue with our experts, those who are already dealing arbitration. And there were some important issues which came out. So one was first of all, the fee of the arbitrator, that what should be the fee, maximum fee. So already it is the Supreme Court has given ruling that maximum fee they have capped to 30 lakh for highest maybe 500 crore and more claim. So there is a capping has been given. So whether we should allow, because I am also part of one arbitration proceedings, and fortunately or unfortunately, this chairman of the particular arbitration tribunal is Supreme Court Chief Justice, ex-retired Supreme Court Chief Justice. So for 6 months, we were just discussing about the fee in 6 or 7 meetings. And finally, he said that I cannot continue if you want to have more than, say, 30, 40 sittings, because my time is very valuable. So that cap is not applicable if the sittings increases more than, say, 40 or 50 sittings. Then I will charge something else, 3 lakh per sitting or like that. So that order he passed. Then it was when parties, they said that we don't agree to your order. so we don't want you. I mean, so finally then after 1 year he resigned from the AT and new AT was set up. So the fee has become a very important element. So that is why they want to discuss this issue, that what should be the fee. Then who should be the arbiters? Because there are concerns from different sectors that who should be appointed, because what is happening in NHAI, what we see mostly it is IAS officers, or even now judges are also being appointed, because Sarod in panel, they have a lot of judges, they have arbitrators, IAS officers, and technical experts also. So that is another issue which was discussed, in fact, in some of the meetings which I participated, because they were experts from different countries. They were also giving opinion to the committee. And then I strongly wrote in my comments that it should be subject-specific expert on the topic which is being discussed. So he should only be allowed to be arbitrator. And this also finding now favor with many other sectors, that yes, they want that it should be subject-specific expert who should be appointed, because they only can understand the gravity of the situation and how to address the issues, claims issues. So strongly, many sectors, they have raised this issue, and from IRC, I have also written strongly that it should only be technical experts which should be appointed arbitrator. Similarly, there are various issues that what should be the length, what maximum, how much period we should allow for arbitration proceedings. So I think the law allows at present, the Supreme Court says 1 year, they want that it should be completed. But the judges feel that 1 year is still less. So that also is being discussed, that what should be the maximum and whether we should allow fee increase. That is what is the demand of various judicial officers. That if it increases, I mean, if the time goes beyond 1 year, then there should be certain addition to fee. So that matter also is under discussion. So, I mean, there are other issues also regarding procedures. So this act is very important. I think you can also submit after the panel discussion is over, we can give our recommendation as well as we seek your comments also. If you have any comments on various issues, being you experienced arbitrators and other even what you are facing in your departments, a lot of claims you are facing. So if you have any suggestion to the entire arbitration process or conciliation process, in fact, I was part of some of the conciliation process also in the ministry, because 2020 there is an elaborate circular of the ministry that we should first try conciliation, and there is a mechanism which has been set up that it is at the DG level, Director General, Ministry of Road Transport, that conciliation proceedings should be done with the director of the company, and we should try, but I don't know if there are very few cases which are being settled, because ultimately one or other party, they challenge this conciliation, whatever amount we come. So that conciliation also is being debated with what should be the, final, whether it should be binding or not, because otherwise we are keep on challenging. And government is they are the main culprit. They never agree because they feel that everybody wants to be safe. So we have to have some comfort that how the government officer will agree to this. So unless there is a strong law which protects the government officer also, otherwise this is also being questioned that who has agreed to this conciliation and who was the officer and the responsibility fixing and all. These kind of things are also there in the department. So I think that issue is also very important, how to protect the government officers who are part of the conciliation proceedings because they are serving officer. Arbitrators are normally retired officer, but conciliation is the serving officer mostly. In conciliation committee there, but in the ministries, that circular, it is the DG who is the conciliator from the government.
Okay, but in NHAI it is all retired officers.
Your conciliation CCA, that committee, in NHAI, this system, they have all the three committees, the retired officer, but in the ministry's circular, it is the DG who is doing the conciliation.
There are three committees, and they are at liberty to select one of the committee. So we don't enforce selection of the committee. Still, sometimes the doubts are raised that they all are
So these are some of the issues which I am flagging. I think I will give chance to other panelists also. Thank you.
Thank you very much, Nirmalji, for giving insight and again the latest development in matter of conciliation and arbitration. Now I'll request Sri C.P. Joshi Sahab to give his views on the subject.
Ladies and gentlemen, it's honor to be with you. The subject is vast, the law is inadequate, the system itself is inadequate. That is my opinion. I did my law, I became advocate also. I'm practicing arbitrator. I'm doing 6 arbitrations right now. Sometimes it becomes very difficult to take decisions as an arbitrator also, and we face that dilemma. From the standpoint of view, instead of going in for issues, I will put forth one of my own cases. I was working as chief engineer of PWD, wherein a contract was there, a BOT contract, build, operate and transfer, wherein I suggested to my government that we are not in a position to give our land to this contractor for a 4-laning, 6-laning mixed project. And since, as we are failing as an employer, it is our duty to foreclose the contract by paying him what he has done. I requested the engineer who was appointed as an authority engineer to give his report. I got my own evaluation done, and as a chief engineer, I submitted to government that we should close this contract by paying 127 crores. It went to government, nobody took the decision as usual. It remained pending. I became the secretary. The same question was put to me, but then there are systems in the government, so one has to go to the finance, one has to go to the planning department, solve the issues, get the solutions. The costs were rising, and the contractor eventually went to High Court, Mumbai. He got a sole arbitrator appointed. It was a decision given, well, nobody opposed because we were not given the chance. We were not knowing that the contractor has gone in the court. The sole arbitrator, after so many hearings in a year, because it is binding on sole arbitrator to give decision in a year, he gave the decision that the chief engineer was correct and that he has recommended 127 crores, so that should be paid with interest at rate of some 12% plus pendentalite interest till you pay. The decision came, again nobody acted on it, probably the officers at lower level again deterred. They did not recommend either to pay or to go into the court of law. One person was there who said we should appeal under section 34 against this award. When it came to government, finally in the courts, again in High Court, because it was heard on original appellate side, we got a decision, a decree, that 90 days are over, you have not appealed to any court, so now pay. When the decretal order came, that time there was governor rule in our state. So I had no choice but to prepare an office note. I thought I should at least now at this stage moderate, act something like that. And then I called the contractor, entrepreneur, had a discussion, series of discussion with him. We formed a committee. The committee negotiated with him that what you are asking is something too much. So let us try to reduce the amount. Let us try to reduce the interest burden on the government. And we agreed to a sum which we proposed to our top brasses. It went through finance. It went through finally the chief secretary's office and went to the governor. The governor finally said that it is a decree of the High Court. So since the agency is accepting, instead of some 600 crores at a 356 crores, you should pay. He signed the file came in, it was budgeted, and later on it was paid. Everything was closed, fine. The new government came in. And they started asking questions whether you took right decisions or not. So it's my own government filed a case against me as the secretary, and it went in the court, again High Court. Since the background of the case was known to High Court, probably, they heard me and gave a decision, a rightful, proper decision after going to some 86 pages. Instead of making scathing remark on the minister, they said, short of commenting on the government, we are ordering the government not to file such frivolous cases. Because it was said like this, the government went in against the Supreme Court. The Supreme Court asked a simple question to the government, are you going to file inquiries against or some indictment against your officers who took this decision? There they could not answer. The Solicitor General could not answer. He did not get any directions. And then finally, it was dismissed. And the award stood. The High Court said that the money should be paid. The question came that 2 years passed in this. The money that was to be paid at 356 crores again went to 450 because of 2 years interest. Interest burden goes on mounting and mounting and mounting. So the simple issue I'll tell you is the responsibility of the employer is one of our issues, is this, that somewhere or the other we have to take this responsibility that we should propose a solution which is acceptable to both parties. In most of the cases, if we take such a decision, the contractor is always ready to accept it because he gets some money and he gets out of the contract. So while making a law on arbitration or law on contracts, I have written, because of this case I faced in last 2-3 years, they passed all my pensions and everything, that was clear, there was no doubt. But then I felt like my decision is being challenged. It never happened in my career. So I fought for it. I fought at personal level also, and I won. That winning had no meaning. So I wrote to Law Commission also, I am writing to many societies also, many high courts also, and I'm pointing out to them that in the law, there should be some protection to officers who are taking decisions in the interest of the government, interest of the public at large. Because, you see, a lakhs of cases like this are in Maharashtra, the statistics will tell that we are facing some 9,000 cases, either in the court or in arbitration. Recently, one arbitration order I passed, I requested, I was one co-arbitrator. In one other case, I was presiding arbitrator. I requested both of the governments to accept this and close the case. But then somehow or the other, officer at junior level, like at ex-junior level, is writing to the government that we disagree, we feel that there is some aberration and we should go to the courts of law. Now again he goes to that civil process of section 34, district courts, high courts, Supreme Court. By the time the award comes out, it becomes a very huge burden on the whole system. So the law should have this facet also, that the officers who take decisions are protected by law. Secondly, the interest that has been specified in the law is like 15 to 18%. It's written there as a figure. Wherein the market situations changes, and right now the interest capping is at 7.5. How can we pay an interest of 15%? In one of the recent cases in front of me, my two co-arbitrators said that it is written in the law. I told them, sir, it is written in the law is okay, but when we are arbitrating the matter, we are supposed to arbitrate on this matter in the interest of the public. I suggested that we should pay an interest of 8%. Then there was some discussion. Finally, we agreed to 8%. We issued and solved the case. I convinced both of them. So this second matter which I bring to the notice is this, that the government should come up with some policy or some provision in the act about this interest burden which they are causing. And the third is litigation. So many cases, either we go, just like NHI, we go into the courts of law just to avoid some responsibility on our shoulders. Either the lower officers who are not trained, because the executioner concerned is not trained, it does not have a trained legal mind. Second thing is that when we bring it at middle level, the superintendent engineers who take the decisions, they also feel their promotions are very near to as chief engineers. And they avoid the decisions. When it comes to chief engineers, he feels, I may be secretary, I may be something like that. So they differ on the decision. So people making decisions need to be very firm, need to be legally trained, and they should act best way in the interest of the public. So taking out decisions, finalizing the cases, and instead of going in for court cases, if we can sort out the issue by mediation again on that matter, or for that matter, take it to a committee of 2-3 persons and settle the contract, settle the dispute, it will be a better cause. The last case I will put forth and close my discussion is one case which you must have read it in papers. In 1973-74, we had a contract of BOT of 2 crores of rupees, 2-3 crores. The money was very small that time. It was a bridge to be constructed, to be tolled, something like that. The entrepreneur that time had a dispute of 60 lakhs. The dispute went to arbitration. The arbitrator gave an award of 90 lakhs and said that, well, it should be closed. Had I been chief engineer or had I been secretary at that time, I would have said, yes, please close the matter, pay him, and let us get out of this situation. This did not happen. They went in district court. District court gave some decision, which was challenged again in High Court. This process went on for 27 years. And finally, they came out with 18% interest to be paid on that whole amount. The whole amount mounted to, I remember, 335 crores. When it came to government, again it was not decided. It remained there as it is silent for 3 years. It finally was sent to Supreme Court. Supreme Court dismissed it in 3-4 hearings after 1 year, and then we had to pay 435 crores for a simple reason that nobody took a decision. I was asked this, that Mr. Joshi, when you were there, why this decision was not taken? I told them, sir, in whole of my 4 years tenure, while monitoring all High Court cases, the matter remained sub judice. I could not tell High Court that I want to withdraw, I want to do something, because it was strongly reported by my officers that we are winning the case. It's always there in the formats, in the reports, which are submitted to you monthly. It comes as if that we have strongly put our case, we are fighting, and we are sure of our win. What can you do? For a small thing, we paid a huge amount of money. It was not from our pocket, but I feel like it's a great loss. At one time, I fought for another case. I could not fight for another case because I was out of the system. I retired at that time. So I'm inclined on this. I agreed to be a part of this panel to put forth this view passionately, right from my bottom of heart. I will say that we should make decisions. We should take responsibility of decisions. We should write on files very clearly that if we don't decide this right now, we are going to pay heavily in future, and make it mandatory to our ministers to take those decisions at their level. Or, well, that time it was governor. The governor studied my file for 3 days. He asked many questions. I was standing in front of him. I told him the whole case. And when he went through and finally he said, then why did you discuss with him for reduction of interest rate? I told him, sir, is it good to pay 15% interest, which is awarded by a judge who was sole arbitrator? I feel something like about this, that right now the FD interest is at 6.5%, so why pay? So I have reduced that to a reasonable amount, and therefore we should finalize the case. He agreed to, and we finalized. He also said that since I have made that decision, and governor himself, that when the new government challenged courts of law, The governor said I should be made a party to it. However, they cannot make a governor of the party. So it was against me, and then I fought, and we won. These two cases, I'm bringing it to your notice. Similar are the cases in most of the states across India. I will I will flag out this issue of taking decisions at the right time and making our seniors to forcefully accept them will lead to removal of lots of disputes. And instead of fighting and filing the cases, it will be better to make a midway solution to agree to some part of payment and finalize the cases. Otherwise, the interest burden is very high. Thank you, sir.
For giving a rather your personal experience to the audience, how the decision can be taken and what can be the consequences. I still remember the honorable minister's speech that वो कोई decision लेना नहीं चाहता है, audit आ जाएगा. So it's I mean it's a hard reality of the system, but once we start doing something, if out of 10, one is doing, then it's a questionable. If all 10 are doing, then nobody is going to question, then it becomes a rules or precedents. So thank you very much for giving such a good your lessons you have learned and sharing it with. Now I'll request Sri Arvind Kumar Jain, Engineering Chief UP, to share his view.
It's okay, sir, for giving me an opportunity to speak on the subject. In fact, I feel very shy to speak on the subject in front of such an august gathering of experts, because I am not an expert on the subject. Still, I would like to flag some issues based on my field experience and observations. You see, as the projects are becoming of bigger and bigger size day by day, so the complexity is also increasing in them. When I joined as assistant engineer in the department some 30 years ago, then this dispute, arbitration, conciliation, these terms were unheard of. But as I progressed and the size of the projects increased, then of course the disputes arose, and the scope for arbitration and conciliation came there. Now the basic question is that why dispute? Why dispute arises? The dispute arises because of the ambiguity. If ambiguity is there in the contracts, then definitely somebody will take advantage of it, and the dispute will be there. If clarity is not there, then dispute will be there. So if we can make blur lines clear, if we can do away with the ambiguity from the contracts, then probably the disputes cannot arise. In fact, nowadays what I am seeing is there are contractors who are bidding only for arbitration. They are not interested in completing the project. They are just interested in going into the arbitration. They are always looking for an opportunity to create a jhagda and just enter into an arbitration. This is the reality. I have seen some of the projects in my state, UP State Highway Authority is there. That was created in 2004 for developing the state highways on the lines of national highways and on the lines of NHAI on PPP mode. That organization constructed only 3 roads until now. And 1 road was started and it got closed. And all 4 projects got arbitrations. And we constructed the projects of amount some 2,000 crores of rupees, and the arbitrations are more than 2,000 crore rupees. So see, this is a ridiculous situation. As he was reading that the amount of arbitration claims is running in lakhs of crores, 1,76,000. It looks like in a department. We are talking about an organization, as if arbitration itself arbitration claim itself has become an organization. So for people, for contractors, for the arbitrators, for their pleaders, it has become an opportunity to take advantage of the situation. So we, as engineers, we must think, as authorities, we must think how to reduce the disputes. Can there be a situation where there is no dispute? Yes, there can be. You see, all of us belong to the engineering field. We come from engineering colleges where no arbitration type thing is taught. We start handling the projects right from assistant engineer stage. There also, there is no training of contracts, how to handle the contracts, how to draft the contracts. We just learn from our seniors and from the customs and start doing the things. So there is a need for clarifying the things, for bringing out the clear-cut guidelines on the contracts. The contract should be drafted in a very unambiguous manner. And there should be clear-cut do's and don'ts. In fact, on the right of the contract, on the first page of the contract agreement, there should be a list of do's and don'ts for practicing engineer, so that an executive engineer or a stand engineer who is handling it, he can see that yes, at what time, what is to be done. Otherwise, what happens, the contractor starts throwing correspondence to the department on various things, and department keeps on ignoring them. And on one day, suddenly, he comes with the claims, and then we find that we didn't answer his letters on time, and because of that, some dispute has arisen, and we didn't take decision on time. We didn't give decisions on time in the field. So likewise, in that manner, the disputes starts piling up, and it becomes so big that it goes into the arbitration, and then the arbitration awards and all those things keep on coming. So, in fact, this Indian Roads Congress, actually I wrote yesterday also in my agenda that they should come out with some specific guidelines, commentaries on how to draft a contract and how to manage a contract. So if those things are available to us, then probably the disputes can be reduced. Another thing about arbitration I would like to say is that after, you see in any contract agreement, you can't impose a penalty more than 10% of the project cost. So can't be there a limit for claiming the arbitration amount? Suppose the project cost is say 100 crore, then can there be a limit, okay, that if any dispute is there, that dispute amount cannot be more than 10% of the project cost? How it happens that the dispute is more than the project cost sometime? The project cost is say 100 crores and dispute is of 200 crores. How it can happen? How the losses can be piled up to 200 crores for a 100 crore rupee project? So this seems ridiculous. So in fact, we should look into these matters. Then only the disputes can be reduced and the arbitration claims can be reduced. Otherwise, the government will be sold off just because of arbitrations. If arbitrations are running in lakhs of rupees, lakhs of crores of rupees, and even if the award is say 1/3 or 1/4 of it, then also they are in gaining side. So these basic questions should be addressed by the competent authorities. Whosoever can take call, they should take call on these basic things. Then only we can deal with the arbitrations and disputes. Otherwise, we are already in mess. Thank you very much.
At least addressing to one of the issue of dispute, that ambiguities in contract. If while preparing a document, some care is taken, then I think 50% of disputes wouldn't arise at least, or we wouldn't be getting chance to other party to arise a dispute. So far we have heard largely a government side of or employer side of dispute. Now I'll request Sri Rakesh Ranjan Sinha, Vice President, Contract and Legal from DR Agrawal Infra. We also would like to know what is contractors' view on the dispute, because we all were largely with the government. So we would like to really hear from the other side of the.
Thank you, sir. Thank you for the opportunity. Uh, we are talking about projects, and when there are number of stakeholders which are bound by the contract. And when there is a contract, it is a written words, and it is said that language is never perfect. You cannot actually capture the imagination or expectation of either of the side, whether it is a developer or the contractor. And it is generally seen that profit for which the contractor enters into contract, generally the other side thinks the profit as a seen word. That it is wrong to expect a contractor to earn profit. So basically dispute or some kind of dissatisfaction arises from that angle. And when there is a contract, there is bound to be some dispute, and it is going to happen. It is unavoidable, so it is better to manage that. If you cannot avoid the risk, better to manage that. So that is why we are here to discuss how it can be managed. Generally, the government is very proactive. Now the employer is also very proactive to introduce multi-tier dispute resolution mechanism, whether it is a DRV, conciliation, arbitration, or things like that. So what is happening? There is a perspective when the language is not clear. As I said, it is understood that language is never perfect, so there will be some gaps. So the perspective should be there. Generally, there are a lot of messages being circulated in social media as well. People are sitting before a digit. One is 6, one party says it is 6, the other party says 9. And when you see from each side's perspective, both are correct. So it is better to see that particular from a perspective given by the contract. Whether it says what angle is prescribed to see at that particular digit. If the contract says it is to be seen from this angle, then it might be 6 or it might be right. Only one thing will be correct. And when we are dealing with the contract, what is happening, we are basically doing the technical projects. The thing, most of the people are technically oriented. As the sir was saying that there is a lack of legal application on that. So generally, technically speaking, people are more oriented to get things done. They said then when you are rather contracted to perform, just perform. Why you are talking about the rights and things like that? So that right or other perspective come from the contract itself. So it is better to have, since the contract we are doing technical thing and bound by the contract, so technicality and legality, there are two aspects which is inseparable in construction contract. So things have to be seen from both the other sides. As Pawan Kumar sir was showing, there are multiple disputes, and the stake is so high that it is running thousands of crores, and nobody is willing to budge their position because the stake is running in crores, multiple of crores. So what is happening? There are multiple multi-tier dispute resolution mechanism, but what is to be seen whether that is efficacious or not. We are dealing with the DRV, we are also dealing with conciliation. Once the DRV decision is coming, whether we are going to honor it. Generally what happens, when we are seeing that there are another 5 steps to pursue, why not to pursue the second step? So people like to push it to the next stage. And for that, what is happening, there is a new concept, pay now, argue later. So that is why Niti Aayog and other policy is coming, where there is a certain binding that you have to pay certain amount, say 75% and 80%. Against some BG, then only you can go to the next stage. So why this? Because the money belongs to the project. The value of worth of the money is when you are getting that money during the construction itself. There is nothing, that money is only good for the, balance sheet when it is coming after the completion of the project. So it is better to have the money during the construction. When you are hungry, you will enjoy the food. Likewise, when the money is required during the construction phase, that money should come during the construction itself. There is no fun. Otherwise, it is just a KRA of legal and contract team that you have finally won. But the project will always be the loser when the money is not during the construction stage. So, in my opinion, there should be certain concept of certain recognition of enforceability part of the dispute. So when the decision is there either through DRB or arbitration, we should honor that and we should move ahead. In every organization, whether in the contractor side or the employer side, there are number of people, there is a whole lot of hierarchy. Even if it gets stuck in one step, the people generally don't take responsibility for that because there is so many retribution, either there will be some kind of audit, vigilance or things like that. So people generally want to take a third party decision. So there might be some issues in taking decision because there will be large scrutiny and there might be some repercussions on the professional front as well. So I think the accountability at each stage should be fixed, either from the contractor side as well. There should be some marking. Actually, there is some grading as well. The sir was saying that contractor is entering into the project only for litigation. When the litigation, when the money, when the contractor or any winning party will see the color of the money, nobody knows. Whether it can be in a year or 5 years, nobody knows. What we say generally in contracting side, we are filing this case, I don't know when I will be there in the system to get that money or not. So that perspective is to be changed, whether it is from the employer side or the contractor side. And when in the current setup, we are introducing the PMC as well, either in the form of IE or AE. And there is also some sort of, there must be some accountability at that front as well, because either the contractor is winning or losing or the employer is winning or losing. The consultant, basically he is advising and is not part of that, what do you call, the fruit. So in short, that would be my point, that the system, there must be some efficacy and there should be measures to give efficacy to any procedure in dispute resolution mechanism. That is my submission. Thank you, sir.
But Sinaji, for showing your side of issues. Now I'll go to the, I would say rather it's a sort of triangle. The third side is a consultants, be it design consultants or be it a PMC or authority engineer or proof consultants. So I'll request R.S. Sharma Sahab to address all these 3-4 types of issues.
Of you, and thanks to President Sir for giving me an opportunity to say something about the dispute management. Since the works, these items were not identified or assigned, I assumed for me it is for the role of the consultant. Okay, I have prepared accordingly. As all of you know, it has already been told, there are 2 types of the disputes and the causes also are there. One are genuine disputes, other are fabricated or false, or this has been proved by the slides what Pawan Kumar has shown, because the settlement amount is nearly 34% of the disputed claims. So disputes are actually originate when there are claims from the contractor side mostly. Sometimes they are also from the department side when the contract is terminated. And the contractor then again goes to the court, or there are some claims. The action is taken by the client actually. So on the action of the client, the dispute arises. Otherwise, disputes are claims from the contractor side. So what are the causes? You know, the scope of the work increase or decrease, there also the problems are there. Site is not handed over to the contractor in time. As we have seen, most of the claims arise because of the site was not handed over. So it is a serious issue. We have to work on it. So once I'll make some suggestions for the conciliations, then the, say, 60% of the cases can be avoided. So role of conciliants, actually there are two types of conciliants. First is the DPR conciliant, the DPR stays, and second is when the actual dispute arises. DPR is to avoid the disputes. What the DPR can do is how to avoid the disputes and framing the contract conditions. DPR conciliants is involved in the design part, giving the scope of the work and framing the contract conditions. So contract conditions should be framed in such a way so that it is clear. Ambiguities are minimized. Other thing is what I'll suggest. See, no document can be perfect, I'm telling. I am working, say, last maybe from 97 onwards, I am in the highways, from NHI, then the consultancy, we are looking at it. We are framing the documents, schedules, lot of things, revisions are there, every care is taken. It is prepared by the DPR consultant, checked at the PIU level, at various levels, again at headquarters. Still, something is left out. Every cases, most of the cases, something is left out. Somewhere they are glaring, something are minor. These things are there. So, you see, there should be some provision in the contract for a variations, say, and the tenders are invited at the feasibility study stage. They are not at detail engineering. So, lot of details are prepared later on. And because of the urgency, the bids are invited at that stage. So, at least 5% variation should be included. If the variation plus or minus 5% is there is no change of scope. So, lot of disputes can be avoided. So, that much risk the contractor takes, and department should also own it. Say 5% is reasonable because even the contingency amount is there, 3% is there. So, everything cannot be taken in the contract. Some scope of work, something will remain. So, if the provisions are there, which risk both the departments and the contract takes, this will help in early completion of the work. This is one suggestion. Second is about this site availability. I've been telling what's happening. We are doing DPR contracts. Lot of things happen. We prepare the land plans, and we do the land acquisition. All 3D is also done. When we go to the site, same alignment plan, where it's superimposed on the ground, it goes in some other khatras. These lot of problems are coming like that. Now what we are doing is, I'm telling, we are preparing the alignment plan suiting to the land required. Because 3D once you do, that means is our land already vested with the government. So these are glaring mistakes available in the land plans. The maps prepared by the state, they are not according to the alignment. And the road is shown zigzag, and road is not like that. It is always in some curvatures or like that. And the scale, again, the thickness of the lines, that also matters because the scale is there. So, lot of things, details, these problems are there in the land acquisition part. What I suggest, and what happens, the PIU or the NHI, they don't have the staff. They cannot verify at site. So these things get verified when the contractor comes to a site. So he does that survey, fix up the alignment plans, then only these things are identified. What I suggest is, instead of awarding the work for the entire contract, we should award only fixing for the alignment and site clearance. This is just one item, this is only 5% of the contract maximum. And then you will know everything. So you give the entire site, fix up the even barbed wire fencing. Fencing is also done. So that when you invite the bids, contractor goes to site, see that the entire site is available. You will have early completion, no dispute, I am telling. There won't be a single dispute on it. Just have the site clear. You do the site clearance through a separate contractor, not the main contractor. Other thing is what is happening, what we DPR consultants are facing. See, in NHI or whatever region, the process of approvals are there. See, it goes on revision. So many revisions are there. So we have, let's say, 10 months contract period. By that time, even alignment is not finalized. So all the key persons who are available, their time period is over. So when the decision's final contract comes after 3 years, those people are who done the real work, they are not available on site. Then you start doing, okay, you modify. At PETC stage, you do the modifications. Again, the cost estimate is revised, technical rules is revised. Again, when you go to SFC, ministry also, some revisions are done. So what happens in the process, something is left out. So these things should be avoided. I don't know, there should be procedure for sanctioning a project. The technical parameters should be finalized before award of the work or before floating the tender. That is my point. Because you float the tender so many times, the bids, means the technical rules are revised. This should not happen. Then coming to the supervision side, this is about the design part. Then coming to the supervision means we are the supervision consultants, authority engineer or the independent engineers. So they should act impartially. They should really act as a independent, but they are not allowed. Because they are again to get their payments from the department. And most of the time, the influence comes from the department side. And what happens, as it has been rightly said by the contractors and others also, see, no one really gains out of these claims. Because what is required is you need money when the contract is ongoing. Cash flow problems are there. So what I say is genuine claims should be settled fast and money is released, at least part of it. See, some part can be left out, but some parts should be released so that work is. Otherwise, you decide out, okay, we don't want to go ahead and terminate the contract. These are all my suggestions. Thank you. My time is also up.
So thank you very much, Sharma sir, for giving a views from the both DPR preparation as well as the execution stage issues. Now I'll request all the participants to raise their questions or something from.
I think there was request from Pandey on this issue. You can give mic to.
Hello. The topic of the subject was the role and responsibilities of the stakeholders. Before going to the, dispute resolution, we have to discuss the genesis of the dispute as well. And the genesis of the dispute starts from the failure of the role and responsibilities of the client or the government. On the first side, I would say, and this I am talking with my own experience. By the pressure of the government or whatever it is, we are forced to do the foundation laying for the project, even when the DPR is not prepared. And award the, give the appointed date, even LA has not been done. So the first and foremost thing is to honor the contract which we have written. The contract says the permission precedent has to be satisfied before award of work, then it has to be done. There should not be any lack of this thing. Once this is not done, in the first instance, when you give the appointed date, the breach of the contract has already arisen and the dispute has arisen. The first thing. Second thing is the disclaimer clause in the contract. When you are giving all the DPR details in the contract, you are enclosing a part of it, giving during the private conference details as well, and you are putting a disclaimer clause. It's unreasonable, Then there are ambiguities which even a first class, a first standard child can understand that this is, such a disparity in the contract. which will lead to the dispute. Just for an example, the role of the government or the client is to give a detailed design, GAD of the railways ROB approved and give the details of the length of the ROB. But when you award the contract, GAD is not approved, but some length has been already given in the contract. And if it changes by the, at the time of the approval by the railway authorities, we say that we have given a disclaimer clause in the contract schedule B itself that there will be no change in the length of the bridge, and that dispute has arisen. This has been discussed, and subsequently it has been taken a decision when the authority is changing, they will consider that. But the dispute has arisen, many of such kind of disputes on that also. The second is the decision-making process is so low. I mean, we are not either taking a wrong decision or a right decision. We are just keeping the decision pending. We must, understand that time is the essence of the contract. Whatever you do within that limit of the contract. If it is 180 days or 2 years time period, we have to do within the 2 years period. If the contract says that LA has to be given the appointed date or within 180 days we have the appointed date, it has to be given. If it is not given, then this is a deemed termination or deemed closure of the contract. Then we have to follow and give a written direction that, okay, this much length or ROW has not been handed over. This is deemed withdrawn from the contract. You complete the project and go away in the 180 days. Most of the disputes will get resolved in the SAT. Second thing, as our contractor friend has already noted, flagged it, that again is the time, he is talking about the time, that when the money is needed, you have to give him. Unless you give the money in the time when the project is required to get funded, then project delays. And once the project get delayed, it is already derailed in fact. Because there are so many, cost with the delay, overhead cost of the site maintenance cost, even legal cost, administration cost, and we don't consider that contractor is going to incur all those costs. We say that since the contract provides 1% of liquidated damage in the contract, we'll limit our damages to 1%. Where is this reasonability on this thing? And that's why there is a dispute. So all these kind of things and ambiguities has to be taken care of while writing the contract. Second thing, there are discrepancies in the schedule A, B, C, D, and H. We say in the B that you have to do a restoration of all the cut embankments. And the schedule H, we say all retaining walls and everything has to be done. But what we have provided in the schedule B, in the drawing attached to the schedule B is a 2 meter height of, say, random masonry. But in the site, you require 8 meter height or even 15 meter height of the retaining wall. How the contractor can do within that schedule H provisions? Because you say that in the schedule H we have written, you have to meet all the coast guard. How can he get? These are all reasonable things. And that's why, there are disputes. Second thing which have been flagged by the Pawan Kumar, that so much of this thing has been settled within 30% reduction. It is only because of the compulsion of the contract to get some money to get running. Otherwise, if he has an holding power, he will certainly not accept it. This is an unreasonable thing because you are forcing him to sign an undertaking that he will not have any contract. That's why he is agreeing to that. Anyway, these are the things which has to be flagged. You have to understand these things. And second thing, regarding the management aspects, when you have given in the contract provision that DG will take a conciliation process, and he has taken the, conciliation process, we have amicably decided the disputes and come out with an compensation amount, then it has to be accepted. because it is all written down. It is all, reasonability has been written down, and this always confirms to the contract, because DG is sitting on the part of the government. He always considers that whatever decision he is taking, he will be questioned tomorrow. So he always takes an action. So my experience says that when a reasonable secretary or government is sitting there, they accept it, and in my case, so many cases have been settled. But in other part of it, everything has been sent to conciliation process. A conciliation, as a conciliation committee which was set up by the NHAI, and the conciliation committee has referred it back saying that who are we to decide on the decision given by the DG? I mean, these are the things which are taking place in the government, and these has to be taken care of. So these are many observations, and this has to be taken care of. Unless the main role of the employer is, complied with, dispute will certainly are going to arise, going to increase, and there will no, respite from such kind of disputes. The first role and responsibility of the client has to be discharged. They have to decide the things, whether it's a DPR, it's the alignment, or a change of scope or anything, and has to be given in writing rather than giving oral instructions, which is a very, very bad procedure which has taken place. Every time we find that oral decisions are given and no communication is done. So there has to be a proper communication, there has to be in time communication. Whatever decision has to be given, it has to be in accordance with the contract condition, rather than forcing the contractor to sign undertaking and getting it done at this moment and subsequently fighting a dispute. Thank you. Thank you very much.
Chalu. First of all, I would like to congratulate all panelists to give their valuable suggestions and opinion. And in my opinion, this dispute issue and arbitration, I think we are inviting them. In fact, knowingly, I can say knowingly. You may differ, but I say knowingly, because if you will go back from the recent trend of EPC, HAM, and BOT and all other projects which we have switched over from the BOQ item to this mode of implementation, then the concept of DPR has gone, more or less gone. Because whenever we talk about the procurement stage and RFP invitation stage, then during the time of discussion, I heard many times from the contractor consultant side, sir, this is a feasibility report. Design responsibility risk is with the contractor. Therefore, design DPR is not being given much more adequate emphasis as it was given before the implementation of EPC and HAM, when the design risk was with the client. Now it has the reverse part. Therefore, first of all, we should give the emphasis on the DPR preparation. No feasibility report and no gaps should be there. And also this issue should be clearly indicated that, look, my dear sir, this is the item, this is the HAM or whatever may be design risk is the consultant, contractor, but still it should be prepared in a desired manner. Number two, earlier practice I remember that at the time of RFP, there was a provision of detailed deliberation pre-bid clarification meeting. I remember even whole day time, it started to take whole day time to take up their question reply and even written reply and all, and modification in the DPR also. But this stage is vanishing. This stage is, I think, at present, simply they are sending through mail, someone is sending through mail, and they are participating. Earlier stage, I remember during that stage, when of course dispute issues was lesser than the present one due to many other factors, but these are also the contributing factor that based on their feedback, contractor and interaction with the client during pre-bid clarification, major issues was modified in the DBR, and also cost was changed at the RFP stage. Unfortunately, this is happening here. And there was also one more condition I remember, that those contractors who don't interact with the DPR stage and pre-bid clarification will not be given opportunity to participate in the bid. Therefore, they should come and understand. And right now also, once the design risk which is them, and our part is the DPR preparation or feasibility report, whatever may be, and schedules and all, then it must be made mandatory to them that study the documents, visit the field and whatever may be, and come and interact, that what are the gaps here. And later on they are raising the basic issues. Third aspect, which we are missing here, that our preparation of schedules. I can share with you, sir, take the two DPR same DPR, same length, same four lane or 6 lane, whatever, take two identical projects, any two identical projects, and check the RFP. Prepared by consultants or prepared by the client, whatever may be, and check. There will be huge changes in that DPR. Schedule B, Schedule A. Simply what in Schedule A are written. Many projects it is written 90% of land ROW should be provided. ROW word, which is a source of dispute, my dear sir, where we are not focusing on what exactly we are writing here. And in one line लिख करके we are passing on and we are moving. Therefore, I am sure that if all these issues one by one we can address and give much more emphasis, then disputes issue can be minimized. This is my summation. Thank you, sir.
So now we'll take one last comment because we already passed 6:40 and there's a one good program today at 7. We have also got some written comment that will be replied after this last one.
हाँ, ये basically this is getting into brainstorm only. I would start with Mr. Jain's one observation which he made, that there is ambiguity in contract documents. I would take it rather than ambiguity in the contract document, I would say it is a big brotherly attitude of the employer which is at fault. I'll take only two cases, two issues. One is the appointed date which पांडे जी ने जिसको इशू को रेज किया, और एक दूसरा है टाइम एक्सटेंशंस के मामले में. Everybody knows that the authority engineer has to decide on the time extensions as per the contract. But in his service contract, employer says that he will take his approval first, and that approval would never come. And now what happens is that whatever employer is saying, he is not giving any reason why he is not accepting the time extension or something like this. Now a situation is there in which authority engineer has to express the opinion of the employer, which he does not agree, as his own opinion. I mean, you have made a situation in such a manner that there is authority engineer would never be in a position to give any of the decision ever, and neither any credence can be given to the authority engineer's decision in these respects. Now, secondly, we talked about the appointed date. When the contract is saying very clearly that the appointed date is the date on when the conditions precedent are completed, which means 90% of the land is available, who is the employer to declare a appointed date? This is the determination which happens automatically. I mean, it is a matter of fact which would be there, and everything has to count from appointed date. You at best can say that the contractor would not start any work before the appointed date. It is your site. You can always control that. But rather than doing that, because we are under pressure or something of this kind, so this is what I would term as a big brotherly attitude. And all other issues, land is, I mean, one contract you may be able to do, two contracts you may be able to do, but there would be contracts where the problems, because after all, everybody has done only a theoretical work on deciding the alignment and all that these lands are available. And when is it going to be determined that the alignment is fitting the land is available with you with that? Only when you go there and put your bulldozer on. Then only you will come to know that this land does not belong to you, or this land has other person's interests as well. Then only you would know. But so that means such kind of issues would always come. Now, there are two, still the arbitration, one issue is also there, that there are some arbitration cases which are accepted by the employer, and there are others which are not accepted by the employer. Can we see the reason for that? In my view, those arbitration cases where there are evaluation issues, the evaluation done by the arbitrator or by DRB or whosoever he is, wherever that evaluation has been done in an unreasonable manner, there the award or decision would not be accepted. But wherever there is reasonability of determination of that evaluation, things would happen. Now let's take on handling the awards. We must handle interest separately and the principals separately. Principal and the date, on which date, what principal was due, and then the interest rates. At the end of the day, interest rate is nothing but a liquidated damage on the delay on the payment. And there can always be a view which can be taken that the liquidated damages which are given in the contract are a maximum limit, which up to which only reasonable amount can be given. But what happens is that why a contractor would go to the arbitrator? I mean, let's understand. It is like purchasing a 1.5 crores lottery ticket. When he is sure that in any case, 1.5 crore is going to come back to him as an arbitration award, because he has already claimed 1,000 crore, let's say. So anybody is going to feel कि यार 1.5 crore तो दे ही दो, ये तो 1,000 crore के अगेंस्ट 2 crore दे रहे हो, थोड़ा लाफेबल हो जाता है, तो दे दो, इतना मिल जाएगा उसको. So it is a lottery ticket which initial investment is going to come back to him. Then tell me, a contractor is supposed to be the most intelligent businessman on the land. He has to be, otherwise he can't run the business. You look at the situation, the kind of work which he does. I mean, it can't be done without the most intelligent faculties being lying on his side. If he is so, is he a fool that he is not going to spend 1.5 crores lottery ticket when he is sure that 1.5 crore is going to come back, and still there is a bounty to be claimed? Your claim amounts being in general whatever is the claim made in the arbitration cases, the award itself would be something around 30%. I would say on an average or as a resultant kind of situation, it will be 30%. And when the awards are being settled at around 30%, one has to look at it that it gives that the original claims were made, which was in a ratio of 1:10. I won't buy this. I mean, there could be exceptions on that situation, that when you say that the money, because it has to be spent on the same contract amount or on the same works, I'm not buying those arguments. I mean, there can be many issues on that argument, and there is no point in getting into that. I mean, because I have not heard the other party on that side, and maybe there may be merits, but as of now, I am not buying that argument. So what happens is that, I'm just concluding. If the evaluation of the idling alone is done well by the authority engineer, or something is done in those score, I would say arbitration cases would get eliminated on themselves. And there won't be disputes for which we would be having these panel discussions or something like this. These would be common matters. And one thing which Mr. Joshi said, 1 crore rupees of 1973, if it is being paid in today at around 400 crores, it only means 16% interest compounded annually, not even 16%. And I remember in 1992, Maharashtra Krishna Valley project, they got money from people at 18% per annum. If that was the interest rate, I mean, government is not losing. I mean, why we should look at it that the interest rate you are spending, rather than 1 crore, you are spending for 400 crores. You have taken advantage of that 399 crores by terms of the time value of the money. So I'll rest at that. Thank you.
Sir, may I know your good name? Sir, regarding appointed date, though I don't have much to offer because it is linear project and there have to be some land issue. So there are a lot of contractual provisions for that. But regarding claims and conciliation, some apprehensions have been raised. I will give you one example. In one project, we have an AT award of 2200 crore. Project cost is also 2200 crore. But the work done is only 112 crore. Work done is 112 crore. 2 years, 3 years take idling and machinery. We estimated in a fair way, okay, taking machinery, idling and this, it could be 328 or 400 crore. That is authority engineer computation. But the AT award has been 2200 crore. Now this is one case. Sir, no. You are telling conciliation and AT award percentage. So there I am just responding. Another is that in one project, which TPC is 629 crore, and appointed date, completion date was 2011. After 6 years, contractor is coming and raising a claim of 8,500 crore. I repeat, project cost was 629 crore. Appointed date was some 2007, and project was completed in 2011. And after 6 years, in 2017, contractor is coming and raising a claim of 8,500 crore, which we are still contesting. So that shows the ratio, how much time it is being inflated. So that was. no. So, so that's why, Acha, uh, that's why, and whoever are the party.
It is very correct. That 2,000 crore rupee project has got the arbitration claim of 2,000 crore rupees and work done was only 100 crore.
400 crores today. I mean, how can you pick the amounts?
No, but you have to. If the dispute is being raised.
Anyhow, thank you. That was just a response. Okay, that was just a response. Okay, thank you.
Yes, sir. Yeah, of course.
Thank you, sir.
I think it's a very large issue which needs maybe a full day or even more seminar. At this point, I'll request Sri Nirmalji. We have got some comments, so if he can briefly answer the same and then concluding remark. We have got another.
There are three comments which we have received. One, so they are basically, one is saying that I agree with Nirmalji about arbitrators should be having expertise in the area. The same is also mentioned in the Integrity Pact. But under the clause appointment of independent external monitor, there is a condition that Commission would not consider candidature of officer who has served in the same organization. In fact, while appointing arbitrator also, we keep in mind that when IRC is appointing an arbitrator, we don't appoint the arbitrator from the same state. Similarly, from the same organization, we never appoint the arbitrator. So that is true for all organizations. But it should be from the same, same experience. It is a road sector, means road project means road sector experience. So it should not be from the same organization. Otherwise, it will be challenged immediately in the court and court will disallow that. Another comment is from Mr. Rachit Seth, consultant. CP Jain appreciate the heartfelt experience being shared at such platform. I agree with A.K. Jain on the issue of contract itself, then agree with Sri R.K. Sharma on having ROW alignment clear before execution. Then the third one is another from GM Tech NHI, Mr. K.K. Arora. He is giving some suggestions for amendment in the MCA. So the third one is from Sri K.K. Arora, GM Technical NHI. He is giving some suggestion to amending the clause in MCA. So there are some suggestions I will pass on to Pawan. So you can consult Pawan and then if appropriate, I think they can consider.
If you want NHI, this August gathering recommendation, IRC recommendation, giving Pawan and Pawan giving to NHI might not resolve any.
Because he is because basically it is NHI is MCA he is talking about. So I think he can address that better. And because there is time scarcity also, otherwise we can discuss on all the issues. So I know that there is so much of interest in the subject because everybody, all the PWDs, everybody is facing this issue, claims and disputes. And we need to have a larger time and larger, maybe more brainstorming on this issue. So maybe we'll have some workshop on this particular area and we will come out with some concrete recommendations so that we can share with all the concerned authorities. Even Goyal Sahab also raised some issues during the council meeting. So I know you are veteran, so and you're all working in the same area, so we know that interest and okay. And time is approaching for a very interesting cultural program which is going to start very soon. So thank you very much for this successful panel discussion. We had the views of consultant, contractor, government, and other comments. Thank you very much. Thank you.
Now I request to Mrs. Shobha Khanna, retired Superintending Engineer, PWD, Madhya Pradesh and Council Member, IRC, to present a movement to panelists.